Good afternoon, everybody from Hong Kong. This is Sarah Grimmer, the Secretary General of the HKIAC. Welcome to today's webinar on domain name dispute resolution. Today's webinar is the second in a series of 3 webinars dedicated to the 3 elements to be satisfied in order to successfully challenge the registration of the domain name. Today's webinar is focused on the second element, namely the question of whether or not a domain name holder has rights or legitimate interests in the domain name. Next slide, please. And next slide. Just as a reminder, this is a 3-part series, and the first part focused on the first element of the test under general domain name policy, typically the UDRP policy, but also other policies. And the first element is whether or not a domain name is identical or confusingly similar to a trademark or service mark in which the complainant has rights. Now, we dealt with that element in some detail 2 weeks ago on the first webinar of the series. And if you are interested in listening to that webinar, you can do that by accessing our audio-visual library from our website. And there you will find the recording of the webinar as well as all of the slides from that first webinar. But as I've mentioned, today we're going to be focusing on the second element, which is whether or not a respondent has rights or legitimate interests in respect of the domain name. And then the third and final webinar in this series will be dedicated to the third element of the test, which is whether or not the domain name has been registered and is being used in bad faith. That will take place in 2 weeks' time at the same time, so Monday the 14th of September at 3:30 Hong Kong time. So please do join us for that as well. We will also be running this series in Chinese Mandarin starting in September, and the exact dates for those webinars will be released shortly. Next slide, please. So today's webinar is going to consist of 3 short presentations, and the last part will be dedicated to a discussion time based on your questions. So please do send through your questions through the messenger function. And just so you know, I will be moderating the Q&A session at the end, and I will be doing that on an anonymous basis. So please feel free to send in any questions that you would like the speakers to address. So turning now to our speakers, we are very grateful to have 2 experts with us today. David Kreider will be speaking first. He is an independent chartered arbitrator with offices in Hong Kong and New Zealand. His career includes, amongst many other things, 14 years as general counsel to major telecommunications providers China Mobile and Vodafone New Zealand. He has served as arbitrator in many international arbitrations, over 40, and has issued more than 170 domain name dispute decisions as a panelist under multiple policies. He's a licensed solicitor and attorney at law in England, Hong Kong, New York, New Jersey, California, Florida, and Washington, D.C. And David speaks and reads Mandarin Chinese as a second language in addition to his native English. Also with us today is Karen Lee. She is counsel in the IP and TMT group at Mayer Brown in Hong Kong. She advises on domain name issues and has filed and succeeded in over 150 domain name dispute resolution procedures under multiple policies. She also handles large-scale transactions, assisting clients in implementing their digital strategies through technology outsourcing, software development, and licensing contracts, as well as assisting in the commercialization of their IP and data privacy issues. She was named a rising star in intellectual property at the Euromoney Asia Woman in Business Law Awards in 2016, and she received last year's award from the Hong Kong Law Society for individual gold pro bono services. So before I hand over to our guest speakers to deal with the topic of the day, let me first of all give a brief overview to listeners of HKIAC's work in domain name dispute resolution, generally speaking. Next slide, please. So HKIAC provides services in domain name disputes in respect of multiple policies, and you see on your screen a list of all of those different policies. as divided between generic top-level domain names, new generic top-level domain names, and country code top-level domain names. Our services are most frequently called upon in respect of UDRP cases and cases under country code top-level domain names, CNDRP and HKDRP, and those concern domain names with the top level as .cn and .hk respectively. We also provide services with respect to .ph country code top level domain name, so that refers to the Philippines. Next slide, please. One thing to note is that our work under UDRP cases is done in our capacity as one of the 4 offices of the Asian Domain Name Dispute Resolution Center. So we are the Hong Kong office, and we are joined in that venture by CTAC in Beijing, AIAC in Kuala Lumpur, and KIDRC in Seoul. By contrast, our work under CNDRP and HKDRP cases is done in our standalone capacity as a service provider authorized in respect of those policies. Next slide, please. In terms of what experience we have every year under the different policies, this will give you an overview of our 2009 work. In 2019, sorry. In 2019, you will see that most of our work was under the UDRP. So approximately 58% of cases filed with us were under UDRP, 38% of cases filed under the CNDRP, and then a smaller proportion filed under HKDRP. And that was for a total of 182 cases last year. And that's generally what the typical annual breakdown as between policies looks like. And the average, or the total number of cases is typically around 180 to just over 200. Next slide, please. So what I can say is that from the point of view of a service provider, we have an important vantage point because we oversee literally hundreds of domain name disputes every year. And what I would like to do now is just briefly give you a flavor of the kind of work that we see and the kind of cases that we see through our statistics. So here you see on the slide our statistics in terms of the geographical origin of parties in our cases. You will see that the top 10 geographical origins or nationalities of parties in our cases are those named on the world map here. And what we see from our statistics is that the top 3 users are from mainland China, the USA, and Germany. So representation from the major regions of the world, Asia, the USA, and Europe. In terms of where party or complainant parties are most frequently from, the top 6 users are USA, mainland China, Germany, Hong Kong, the Cayman Islands, and Singapore. And then in respect of respondent parties, on our cases, we see by a very wide margin, the most frequent respondents are from mainland China. And then next in line, we have the USA, Hong Kong, Bangladesh, Macau, and the Philippines. So in terms of respondent parties, we have a very strong representation of respondents based in Asia. Next slide, please. In terms of languages, what we're seeing is that our cases are mainly being run in English and Chinese, but the majority of cases require Chinese language proficiency. So most of our, or just under 2/3 of cases are run in Chinese, and just about 1/3 are run in English. And then what is notable this year is that we've had a number of cases filed in different languages, in Japanese, Korean, and Russian. We luckily have proficiency in Korean and Russian, so we can administer cases fully in those languages. But we also see in cases like that where the complainant has filed or the registration agreement provides for a less widely used language, we often see requests by complainants to change the language to either English or Chinese. Next slide, please. In terms of appointments in 2019, we made just under 200 appointments, 195. You see there on the left, the split between the different policies. And then you see on the middle pie graph that there is a very, very strong prevalence of sole panelist panels in our cases, and I think that is reflective of the industry globally. Last year, we only had 5 3-member panels appointed across all of our cases. And then on the far right, you see a list of the top 11 geographical origins of panelists. Hong Kong is number 1 as a legal jurisdiction. And for us, that's not just because we are based in Hong Kong, but that's really closely connected to the fact of the language requirements that we see in our cases, and the fact that in Hong Kong there is a deep pool of bilingual domain name panelists who can run cases in Chinese and in English. Next slide, please. What about the outcomes? Okay, so here we show per policy the outcomes of the cases. So if I can have the next, yeah. Okay, here you see the proportion of cases where the domain name was transferred. So essentially successful complaints filed by complainants. UDRP 96%, CNDRP 93%, and HKDRP 83%, but that's because of a smaller pool. The average across all of these policies in terms of successful outcomes, in terms of transfer, is 95%. Next. Here then you see the number of times a domain name has been cancelled. Far fewer, obviously. And next. And here is the small number of cases where the complaint was denied. So as all frequent users of domain name dispute resolution procedures will be aware, there is a very high rate of success in these kinds of cases. Next, please. So what kind of services does HKIAC provide as a service provider? I think one of the most important things that we do is we appoint panelists, but there's also a lot of other work that service providers do. So, and that's really related to monitoring the process and making sure that cases are moving forward in accordance with the timelines that are included in all of the different policies. But one of the very first things that we do is we contact the registrar to lock the domain name to ensure the status quo while the proceedings is going on, and to confirm the respondent's contact information so that they can be notified of the complaint. We then review the complaint for compliance with the policy and the rules and supplemental rules under the policy. We give notice to the respondent of the complaint. And then we act as a conduit for communications and monitor, as I said, monitor the process according to the relevant timelines. We appoint panelists according to the time requirements in the policy, and that is very much a very important part of what we do. And then we monitor the time period for the panelist to issue his or her decision. And then once a decision is made, we notify the decision to the parties, to the registrar, and trace the implementation of the decision, which will take place after 10 business days, giving a period within which a respondent may wish to commence action in domestic proceedings. And we also notify the decision to ICANN. And then finally, at the end of the case, we will pay panelist fees, and we will, very importantly, publicize the decision on our website and work with the AD/NDRC Secretariat to publish the decision on the AD/NDRC website. And that means that users, counsel, panelists have a treasure trove of previous decisions from which to draw. Next slide, please. So turning back to what we're going to be discussing today. Today we're going to be focusing very much on the second element, when a respondent does or does not have rights or legitimate interests in respect of a domain name, because that can be, of course, an effective defense to a complaint filed by a complainant. Next slide, please. And here what I've done is I've just set out the wording under the 3 main policies that we work with respect to the second element. Compared to the first element in the test, there is no material difference in the wording between these 3 policies. So that's just a note that might inform our further discussion. Next slide, please. So that concludes my overview of HKIAC's work, specifically under these policies. And now I would like to hand over to David who's going to give us an overview of the second element and get into some of the more nuanced considerations that impact cases. Thank you.
Thank you very much, Sarah, and congratulations on those very impressive statistics. Now, may I have my first slide, please? If you're thinking about bringing a UDRP case, keep in mind the big picture of what the policy is all about. You want to be another successful complainant to be added to the HKIAC statistics. The policy is intended to address cyber squatting. Cyber squatting is defined as trademark abusive domain name registrations. Cyber squatting would include a situation where a domain name registrant targets the complainant's trademark with the intent of free riding on the goodwill of the complainant's name and brand to mislead the public for its own wrongful gain. But what the policy was never intended to do was to extend to all manner of commercial disputes, like a dispute between former business partners who are arguing for control over a domain name used by their business. This would not be a cyber squatting dispute, and an attempt to cast it as a UDRP domain name case could backfire and could result in the case being dismissed. The policy requires that the complainant prove, typically by a preponderance of the evidence, that means by the greater weight of the evidence, each of three elements: that the disputed domain name is identical or confusingly similar to a trademark or service mark in which the complainant has rights, and that the respondent has no rights or legitimate interest in the disputed domain name, and finally, that the domain name was registered and is being used in bad faith. The World Intellectual Property Organization, or WIPO, publishes an overview, now in version 3.0, which is a great source for understanding the types of evidence needed to prove these three elements and defenses in a UDRP case. The WIPO overview should definitely be consulted. Next slide, please. To review what we learned in the last webinar about the first element under the policy, a complainant that succeeds under element 1 has standing to pursue a UDRP claim. Element 1 gets you in the door with your case, no more and no less. To get in the door, you must show that the domain name at issue is identical or confusingly similar to a trademark in which you have rights. If you are relying on a registered trademark, just produce the registration certificate to show that your trademark is registered anywhere in the world. On the other hand, if you are relying on an unregistered or common law mark, you will need to produce solid evidence that your mark has acquired secondary meaning. Now, under element 1, your trademark registration or rights need not predate the registration of the disputed domain name for you to succeed. The timing of your acquisition of rights is not important under element 1. Finally now, under element 1, the identical or confusingly similar test. This involves really a straightforward side-by-side comparison. The trademark on one hand and the disputed domain name on the other. And you must ask whether the average person comparing the two would conclude that the disputed domain name suggests an affiliation with the trademark owner. If the answer is yes, then the disputed domain name is identical or confusingly similar. You satisfy element 1, and you've got a foot in the door to bring your UDRP case. Next slide, please. Today's webinar will focus on the second UDRP element. The claimant must prove that the respondent has no rights or legitimate interests in respect of the disputed domain name. Now, some years ago, in about the year 2000, panelists started to recognize that asking the claimant to prove that a respondent has no rights or legitimate interests in a domain name essentially is asking the complainant to prove a negative. And the evidence and the proof is most likely to be within the control of the respondent. So even though under the policy, the complainant is required to prove all three policy elements, there's a procedural twist under element 2 that renders the process a bit more fair to both parties. And what that twist is that the complainant need only make out a prima facie case, which really means the complainant must submit enough evidence to create an inference that the respondent lacks rights or legitimate interests in the domain. Then the burden of producing rebuttal evidence shifts to the respondent. It is then up to the respondent under element 2 to produce rebuttal evidence to show that it does indeed have rights or legitimate interests in the domain. Next slide, please. Under element 2, the test is not whether the complainant has a better legal right or interest in the disputed domain name than the respondent, but whether the registrant, the respondent, has any rights or legitimate interests in the domain name at all. Now, where the respondent comes forward with evidence, especially evidence that predates its receiving notice of the claim, then the respondent will often get the benefit of the doubt under element 2. A claimant, on the other hand, will succeed under element 2 by asserting without contradiction or rebuttal by the respondent that the complainant did not authorize the respondent to use its mark. It never gave permission. That the respondent is not making any bona fide offering of goods or services on its website, and you can submit some screenshots of the respondent's website to prove that the respondent is not commonly known by the domain name, and produce copies of the WHOIS directory to show that, and that the respondent is not using the website for a legitimate non-commercial purpose or fair use. And some historical screenshots of the respondent's website from the Internet Archive would be good proof on that issue. Now, if the respondent does come forward and file a response, the respondent must prove one of the defenses listed in the policy, that before it was put on notice of a dispute, the respondent was using or was preparing to use the domain name in connection with a bona fide offering of goods or services, or that the respondent is commonly known by the domain name, or that the respondent is making a legitimate non-commercial or fair use of the domain name without intent for commercial gain or to mislead consumers. These are the policy defenses, but these are non-exclusive. A few words about what is fair use. Panels who are deciding these domain name cases will be looking to see whether a respondent is really using the disputed domain for the purposes that it claims. If it's a commentary or a criticism or a fan website, is it genuine and is it not for profit? Is the respondent's website in any way misleading as to the source or sponsorship? And is the website a pretext for tarnishing the trademark or for commercial gain? A respondent's use of the domain name will not be considered a fair use if it falsely suggests an affiliation with the trademark owner, if it redirects users to a competitor's website or products, or if the domain is being used for an illegal activity, for selling counterfeit goods or to inject malware. Next slide, please. The Williamson case shows how a respondent can succeed under the second policy element. It also shows, in my view, that real life can sometimes be stranger than fiction. The complainant was the Williamson family. In 2015, it registered the trademark Williamson Wines. The complainant also proved a common law trademark dating back to at least 2003. Now, I say it's stranger than fiction because the respondent is also a family named Williamson that ran an orchard and winery in a nearby US state. The respondent registered the disputed domain names Williamson Wine, without the S, winesingular.com, and Williamson.wine in 2007. The respondent in that case presented proof of common law trademark rights dating back to as early as 2001. I found for the respondent in that case, the respondent's surname is Williamson and the word wine is representative of respondent's legitimate business. Next slide. More and more we see professional domainers, investors who aggregate and hold large numbers of domain names consisting of acronyms, dictionary words, or common phrases to trade or sell. This can be a bona fide business under element 2, but these domainers need to be able to show that they have done some due diligence before registering particular names. The domain names must be shown as being used in connection with their relied upon dictionary meaning, not to free ride on the complainant's trademark. Willful blindness, burying your head in the sand, will not be acceptable. And here I cite the AirTran Holdings case, where the domain name was air-tran.net. The complainant was an air cargo company that had registered AirTran as a trademark in 2000. Now, in that case, the respondent defaulted. And so the panel ruled for the complainant, noting that, and I quote, "It is the duty of respondent to undertake due diligence to ensure that the selection or choice of a domain name does not infringe the intellectual property rights of third parties. It would have been pertinent for a respondent to provide an explanation of its choice in the disputed domain name." And this is what it's all about for a respondent under element 2. Provide proof and a reasonable explanation of your reasons for registering and using the disputed domain name. Now, we occasionally hear about fan websites. One of my favorite cases is Nintendo v. Alex Jones. Alex Jones is a 15-year-old boy who loved the video game Legend of Zelda and cleverly registered the domain name legendofzelda.com, which made Nintendo very unhappy. In that case, the panel decided that Mr. Jones did not have a legitimate interest in the domain name under policy element 2, even though he was not profiting from this fan website. The panel in that case said, and I quote, "The complainant has the right to decide how its mark will be used in the promotion of its product. Although the respondent may have a genuine desire to support the complainant's products, he does not have a legitimate interest in the subject domain name, which is identical to the complainant's mark." And that's the key with fan sites or criticism sites, where the domain name in the second portion to the left of the dot is identical to the complainant's mark. Fair use is unlikely to be found. Now, happily, the panel in the Alex Jones case dismissed Nintendo's complaint because it could find no evidence of bad faith under policy element 3. The panel expressed in that case that if at a later date, Nintendo was able to come up with new evidence of bad faith, they might consider refiling a new UDRP case, in which case it would be up to the new panelist to decide whether or not that case had merit. So the panel didn't go so far as to issue a ruling without prejudice and invite Mr. Jones to bring or the Nintendo to bring a new case at a later time, but nonetheless, it did keep open that possibility. Next slide, please. And so in deciding questions arising under element 2, it often turns upon whether the respondent can produce reliable evidence to prove that the domain name is being used for a bona fide offering of goods or services, or that the respondent is commonly known by the domain name. To summarize my opening remarks, don't try to bring a UDRP case if your dispute does not involve cyber squatting. And remember always, you will likely get just one bite of the cherry, so take the time to assemble and put forward the very best evidence you can muster. This concludes my remarks, and I thank you for your time and attention.
Thank you very much, David, for those insights into some very interesting cases. I will now turn to Karen Lee. She's going to focus on further cases involving interesting and more complex aspects around the second element to the test, as well as tips for users. Thank you, Karen.
Thank you. My first slide, please. So I'll be looking at a few case examples relating to generic domain names and fan criticism sites. So as was discussed, with disputed domain names that incorporate generic or geographic terms, they don't automatically confer rights or legitimate interests on the respondent. Likewise, just because a complainant owns trademark rights that correspond to a generic word, for example, Apple or Alibaba, doesn't mean that the respondent has no rights or legitimate interests. It depends on the facts of the case. So the respondent can establish rights or legitimate interests in a domain name that reflects a generic term if it uses the disputed domain name in relation to its generic meaning, and it's not trading off the complainant's trademark rights. So for example, if a respondent was using a domain name that incorporates the word Apple to provide information on the fruit, and it's not resolving to an e-commerce website where they sell mobile devices, then the respondent is likely to be found to have legitimate rights and interests. Next slide, please. So putting it into context, I want to look at the UDRP case regarding ifunny.com. So in this case, the complainant owned registered trademark rights in ifunny. So the first element is established. The complainant had launched an ifunny website and app which allowed users to create and share humorous content. The disputed domain name consisted of the letter I and the generic word funny, and the panel found that I is commonly used to refer to the internet. The website to which the disputed domain name resolved contained funny content, jokes, and funny images, so the panel found that the disputed domain name was being used in relation to its generic meaning. In other words, it was providing funny content via the internet. There was no evidence that the respondent had been targeting the complainant when it registered the domain name and in relation to its use. So for example, the website didn't copy the layout or any of the content of the complainant's website or app, and it wasn't replicating any logos used by the complainant. The respondent had also been operating another website, fakeposters.com, which also contained some humorous content, and that was established before the disputed domain name was registered. So it shows that the respondent was in the business of providing such content. Next slide, please. So another case that was denied is gorgonzola.city. In this case, the complainant was the registered owner of CB Gorgonzola. So the complainant controls the use of gorgonzola as an indication of origin of the gorgonzola cheese. However, Gorgonzola is also a city in Italy. The respondent claimed that it had registered the disputed domain name as part of a domain name portfolio. So it had registered over 20,000 .city domain names corresponding to cities. The respondent claimed that it was in the process of developing a platform to allow users to search for hotels and restaurants in the corresponding city. At the time, the website resolved to a web page that provided information on Gorgonzola, the city. No evidence had been provided by the respondent to actually support his claims, but in this case, the panel carried out its own investigation. So note that panelists, they can undertake limited factual research into matters of public record, if they so choose. The panel found that the respondent had registered over 20,000 domain names, most of which did correspond to cities. So on this basis, the panel found that there was no evidence that the respondent was specifically targeting the complainant when registering the domain name to take advantage of the complainant's trademark rights. So it found that the respondent had established rights and legitimate interests. Next slide, please. So let's now look at a case where the complainant was successful in establishing the second element. The complainant was a registered trademark owner of Lotto Works and Lotto. It was established in Italy in 1973 and manufactures and distributes sportswear. The respondent was an individual based in Canada and is in the gambling industry. The respondent had a controlling interest in a business that operates gaming websites. It also owned many domain names relating to gambling and allegedly registered the disputed domain name because of its generic meaning. Lottostore.com was inactive at the time, whereas LottoWorks.com resolved to a pay-per-click website that includes links to the complainant and competitors of the complainant. So in this case, the panel found that it was not being used in relation to its generic meaning. So even though the respondent had registered other domain names that incorporated the generic word lotto, it had at least one domain name reflecting a third-party trademark. In this case, it was magnum-4d.com, which reflects a trademark owned by a leading Malaysian gaming company. So as was stated in the decision, if a respondent registers a large number of domain names, it can't turn a blind eye to the possibility that the domain name registration may infringe and violate another's trademark rights. As David has said, you can't just turn a blind eye. Next slide, please. So moving on to discuss fan sites and criticism sites. The right to operate a criticism or fan site doesn't mean you can just register and use a domain name that's identical to the complainant's trademark. This is because the domain name may mislead users into thinking it's affiliated or endorsed by the trademark owner. But if the domain name is not identical and has an additional word in the domain name that indicates that it's a criticism or fan site, for example, AmazonSucks.com or CrappyApple.com, then it may amount to a legitimate interest if it's fair in all the circumstances. So, for example, it won't be seen as fair use if the domain name on one hand is criticizing the trademark owner, but on the other hand is promoting their own products, competing products. So disputed domain names that incorporate a trademark in its entirety with no other words to indicate that it's a fan or criticism site, usually panels find that the respondent has no rights or legitimate interests. However, you should note that panels have sometimes taken another approach where all U.S. parties are involved. It's related to freedom of speech. So they found that even if a domain name is identical to a trademark, it can amount to legitimate interest on the part of the respondent where it's using it for genuine non-commercial criticism of fan sites. But that's more limited than the general approach of if it's identical to the trademark, then it's unlikely to be found to have legitimate rights or interests. Next slide, please. So I want to look at a case that involves 3 domain names. The panel held that only 2 should be transferred. The respondent in this case registered the truth about williamvidovi.com, vidovi-gallery.com, and williamvidovi.com. The domain names are resolved to criticism sites regarding the complainants who sell art and operate an art gallery. The websites allege that the complainants were trading in fake and fraudulent artwork. For vidovi-gallery.com and williamvidovi.com, the panel found that the respondents did not have any rights or legitimate interests because the domain name was confusingly similar to the complainant's trademarks and would mislead users into thinking that it's associated with the complainant and divert traffic away from the official websites. There was no indication in those domain names that they were criticism sites. But with the truth about williamvidovi.com, the panel found that the respondent did have legitimate interests and rights because the words truth about could indicate that the domain name resolved to a criticism site. And the domain name was actually being used as a genuine criticism site amounting to fair and non-commercial use. Next slide, please. So I just want to end with providing a few quick tips that I've learned along the way. So when preparing a complaint, don't just focus on facts that are available based on the disputed domain name. So you need to look outside of the website and outside of the WHOIS search results. For example, conducting reverse WHOIS searches, finding out what other domain names have been registered by the respondent, Do any of them correspond to other third-party brands? If so, highlight this in the complaint and attach copies of the reverse Who search results. Also conduct searches, for example, on the ADNDRC, HKIAC, or WIPO's website to see if there are any previous cases filed against the same respondent. Has the respondent been subject to many other decisions, for example? Several times I found that respondents have been subject to one or more proceedings, and it acts as great evidence to show regular cyberspotting. As David mentioned, you can also consider using the Internet Wayback Machine. So for those who don't know, it takes screenshots of websites over the years at random intervals, so you can see the history of the domain name and what it was used for. It doesn't do it for all domain names, but usually find it to be quite useful. You can consider also doing an anonymous approach. So it's often a technique that's employed in relation to bad faith, but it's also something that's very useful for the second element. This is where you set up an email account and contact the respondent using a pseudonym to see if they're interested in selling the domain name. If the respondent reverts requesting a very high price, then you can use this as evidence that they didn't register for legitimate or fair use reasons, and instead are targeting the complaint and its brand, which is why they're asking for a high price. For bad faith, you can claim that it shows the respondent registered with the intent to sell for profit. It's also really important that when you're preparing the complaint, you anticipate any potential response and address each issue. Some people, they worry about drawing the respondent's attention to possible defenses, so they try and skirt around certain issues. But the problem is the ability to file a supplemental submission is up to the panel's discretion. It's not an automatic right. So if it's a fact that should have been known at the time of filing the complaint, the panel is less likely to grant a right to the complaint to file supplemental submissions, so you may not be able to rebut the respondent's contentions in their response. Lastly, it's really important to provide clear and relevant evidence. It seems quite obvious, but I've seen in the past when I've helped panelists prepare their decisions that evidence is just not provided. Some complainants rely on bare allegations that are not supported by evidence, and rely on the fact that maybe the panel will already take their word for it, or know these facts already, or will do their own research. Whilst panels have the right to conduct simple searches, such as checking the website or doing Who searches, don't assume that the panel will do so. It may not be the case. If you make an assertion, you should always back it up with evidence where possible. That concludes my part of the presentation. Thank you.
Thank you very much, Karen. So to all of our listeners, if you have any questions, please do submit them and we will put them to the speakers. But we do have a first question here, and the question is, if the respondent or domain name owner has availed of domain privacy or privacy protection, and the complainant is unable to determine the respondent's identity, will the complainant still be able to file the complaint? Or will the complainant first need to exert all efforts to find the respondent's identity or approach the registrar with a request for disclosure of respondent's identity? I think from the perspective of the HKIAC, I can offer some useful insight. So this is probably one of the most common questions that we receive at HKIAC. It's probably one of the top 3 questions that we receive where the complainant is having difficulty identifying the respondent and the respondent's email. And the answer is yes, you can still file a complaint, but you would leave the information, the respondent information part in the complaint form blank and continue to file the complaint with the service provider. Then what will happen is we would conduct a prima facie check of the complaint form and then proceed to notify the concerned registrar of the complaint and to request information of the disputed domain name and ask the registrar to lock the disputed domain name and to confirm the information with respect to the respondent. And once we get that information, we then use it to forward the complaint, to forward that information to the complainant and to amend the complaint form and to recommence proceedings once the complaint form is in compliance. Also, with respect to difficulty identifying respondents because of application of the GDPR policy, what we do in those situations is we are in touch with the registrar for the respondent's information. The registrars are under an obligation to provide us with that under the various policies. And if a service provider does not provide that information, then we can contact ICANN to seek assistance, and ICANN will then handle matters of this kind. We have not had to deal with that too much. It's rare in our cases, but that is another aspect of identification of respondents that might be relevant for some of the users online. Okay, does David or Karen want to add anything to my response on that with respect to identifying the respondent? Perhaps Karen, have you seen that come up in your work?
Hi, yes, it has been, it does come up quite often, more so in the last few years, last couple of years because of the GDPR. But as you said, we usually just file the complaint anyway on behalf of our clients and just leave the information blank or say it's protected by Privacy Shield or redacted for privacy. And we make as many arguments as we can based on the information we have available to us, which is, generally what's on the website. And then, as you said, we will be given a chance to amend the complaint once we actually get that information from the registrar.
Right, exactly. Okay.
There's an interesting related question, Sarah. That is what may be inferred from a respondent's use of such privacy services to hide its true identity. And I personally think that this is an evolving sort of issue. I use one myself on certain occasions, and I know domain name registrars are increasingly offering privacy services free of charge as an additional incentive to customers. So I guess in my personal view, it could be worth commenting upon in a situation where the indicia of bad faith is already quite substantial, but I wouldn't read too much into the use of a privacy service standing alone.
I see. David, have you seen that pleaded in any complaints already with respect to the bad faith element?
Yes, I have. Occasionally it is raised.
Yeah, okay. Okay. Okay, so turning to our next question, I will pose this to David. David, there are some cases obviously where a complainant is not able to establish that it has a trademark per se, but where it can establish that it does have rights in a mark and thus has standing to bring a complaint. Now, where a respondent can also establish a right or legitimate interest, but perhaps not a trademark, whose rights or interests should win? Is there any kind of balancing test that happens, or is it simply a question of who registered the domain name first, and it's the first to register doctrine which applies, and therefore respondent wins?
Yes, a great question. Element 2 under the UDRP and the CNDRP and HKDRP all read the same or substantially the same, and it requires proof that the disputed domain name holder has no civil rights or interests. And I take that to mean that we don't balance or consider whether whose rights or interests are stronger. If the respondent can show that it has a civil right or interest, it prevails under element 2. You would not necessarily even continue to look at bad faith if there is a legitimate right or interest under element 2.
Right, and David, you mentioned the third element. Another question is, can element 2 and 3 really be separated? You spoke of the case with the 15-year-old boy, the Nintendo game case, and there, of course, it was found that he had a legitimate interest. That he had, there was no bad faith, and it failed on that ground. But what about where you have a respondent who is found to have legitimate interest? Is there any scenario in which it can also be found that the respondent is also acting in bad faith?
I think not. I think, however, that if you're looking at fair use and Karen and I spoke to some extent about what you need to show a fair use. It cannot be in any way abusive of a third-party trademark right. And that being the case, it's, in my view, it's another way of saying that there must be absolute good faith in the use of the domain name to find a legitimate interest under element 2, and that, as you suggest in your question, the good faith issue is really subsumed within element 2.
Okay, I'll come back to Karen on a related question there, but we have another question first, and I'll put it out to both Karen and David, and that is, if a domain name is idle, i.e. no operation, and it's not a registered, if a domain name is idle and not registered trademark for 10 years, does it have a right to claim against an entity that now uses the domain name?
Who would you like to go first, Sarah?
Maybe I'll throw that over to Karen. Would you like me to repeat that, or you got that?
Yeah, I'm not entirely clear on the question. So if a domain name is not been operating, and there's no registered trademark for 10 years, does it have a right to claim against an entity that uses the domain name?
Yeah.
If I can interpret this question in sort of if there's a registered trademark, for example, and if there's claiming that maybe the registered trademark has not been used for 10 years, but someone else registers the domain name, can so that other entity use that domain name even though the registered trademark has not been in use? That sort of depends on the circumstances. If the registered trademark has not been in use at all, and you can't really establish that let's say the respondent must have been aware of you when they registered the domain name and was maybe targeting you, then it could be difficult to establish that the respondent has no rights or legitimate interest if the respondent is using the domain name for a genuine purpose. I'm not too sure if I've interpreted the question correctly, but yeah. David, do you have any comments?
I'm sorry, I think it might be helpful to have the question repeated.
Sure. I'm going to read it verbatim. It says, if a domain name is idle, no operation, not registered trademark for 10 years, does it have a right to claim against an entity that uses the domain name? Maybe what I could do is invite the person who submitted that question, if if I'm misinterpreting it, or if there's a clearer way to pose it, if you could do so, and then we can repose, unless you'd have something to add to that, David.
No, I'm not certain that I'm understanding the question.
Okay, no problem. We'll move on, and I'll come back to Karen. What I wanted to talk about was you had a case, the Gorgonzola case, where the respondent was in the business of aggregating domain names and had 20,000. Do you think that there's a difference, and that is not necessarily bad faith, but do you think that there is a difference between major jurisdictions as to what constitutes legitimate interest? For example, if you do have a company that's in the business of aggregating and holding large numbers of domain names, is that considered a legitimate business in some parts of the world and not in others? Does it bleed into the bad faith element somewhat? Do you have views on that?
Yeah, I think, as you said, it does sort of overlap with bad faith. I feel like with the second and third element, there's always a lot of overlapping going on.
Yeah.
With someone who's sort of a professional domainer, as it were, someone who registers a lot of domain names, it can sometimes indicate, it can be a legitimate business in itself. There's nothing really, it's not meant to, the UDRP, the HKIAC, CODIFIED, it's not meant to stop domainers who are running legitimate businesses from registering domain names. It's only if they're trying to do it by targeting brands. So I haven't necessarily noticed a huge difference in terms of how different jurisdictions approach it. what I have noticed in terms of legitimate interest is what I mentioned in terms of fan sites. So where as I mentioned, is where both the respondent and the complainant are U.S. parties. Sometimes in those situations, there's a bit of a different approach that's taken, so that even if the domain name is identical to the trademark and there's no indication that it's a criticism of fan site, the respondent can still sometimes be found to have a legitimate right or interest.
Okay. And if I can continue on the theme of fan sites or criticism sites with you, Karen, when a panel is determining whether the website of a domain name is a genuine fan site or criticism site, what degree of commercialization is required or generally accepted?
It's hard to say. I think it's really up to the discretion of the panel. It's not, there's no sort of hard and fast rule. It really depends on the extent and type of commercialization. So as the example I gave before, if you're criticizing another brand and it looks like quite genuine criticism site, but at the bottom you've got, a link saying, if you want great shoes, you come and click on my site instead, and on one hand you're criticizing, for example, Adidas's trainers, but then you're trying to promote your own sports brand, then that obviously could not really amount to a legitimate right and interest. So it's all about the degree and the extent and the type of commercialization.
Yeah, so really highly fact-based and on a case-by-case basis.
Sarah, if I may jump in on that question.
Please.
The WIPO overview has a paragraph dealing with fan sites and criticism sites. And it says that for purposes of assessing fair use under policy paragraph 4C 3i, a respondent's fan site must be active, genuinely non-commercial, and clearly distinct from any official complainant site. I would tend to read genuinely non-commercial as meaning not selling competing goods or promoting competing goods and not for profit for the registrant of the site, these sorts of things.
Indeed, and
yeah,
I think that...
Yeah. Oh, yeah, sorry. I just want to drop and say I agree. I've just, the only times I've really seen cases that have maybe allowed it is where, not allowed those situations, but I've been okay with certain profits being made is small things like pay-per-click links that are maybe automatically generated and might be one or two, but are not advertising competing goods.
Yeah. If on that score, as Karen says, if you have a pay-per-click site that with links to other sites, I think if the respondent can show that it took some steps to ensure that the links are not going to go to competing sites or to places where competing goods are sold, et cetera. In other words, if there's some due diligence built around it, then although it's a very fact-specific question, as Karen rightly says, then the respondent might be okay.
Right, okay. So thank you for that. I think we have time just to clarify the earlier question we were talking about, and we've received a clarification from the person posing it. So the question is in respect of a company that existed for 25 years and had a registered domain name with the SEC. Then it became idle or had no operation. After 10 years, it was found that its domain name was being used by another organization. Can the owner of the domain name file a claim? So, so there the company existed for 25 years, and had a registered domain name, which became idle or had no operation. And if after 10 years it was found that the domain name was used by another organization, would that company have a ground to file a domain name complaint?
Well, I'm happy to have a go at that, if I may.
Yeah, please.
I would say, first of all, we're assuming that the other company is not related in any way, that these are dealings between strangers, such that it could be a cyber squatting situation under the policy. It could be a proper policy question. It would seem to me that the first to register the domain, that company would have to show that it had continuously used the mark, the name, and would have common law trademark rights, such that that could defeat the infringing party's rights. And the fact that there's been a substantial passage of time, I think it really turns on activity and whether a continuous usage in commerce can be shown by the first registrant to prove that it has common law rights. Karen, does that sound right to you?
Yeah, and just sort of taking it a different angle. In terms of a former domain name owner being able to go after their own domain name that's been re-registered by someone else, I have had a few cases where I've dealt with that. Usually it's in one of two situations. The first can be where domain name has just not been renewed because for admin reasons it just gets overlooked. So then it expires and then someone else registers it. Or in situations where it's a disgruntled employee. I did have one case where a director was unfortunately let go. He was the only one that controlled the domain name, and he managed to transfer it to his new company that was directly competing with our client. In those cases, it is very much possible to file a complaint to try and recover a domain name that you used to own. But as David had said, you do have to establish that you have some form of rights. So if you have registered trademark rights that correspond to the domain name, that's best. If not, then you have to establish some sort of common law rights. If you haven't been using the domain name at all, but let's say that you're still using the mark that corresponds to the domain name quite widely. So, press releases you're using on your goods and services, but for whatever reason you just didn't use that domain name. Maybe you have another domain name that you use. As long as you can establish rights in the corresponding mark, so you can satisfy the first element, then you should still be able to file a complaint.
Okay, thank you very much. I think we are now at the end of our time. The hour has passed very quickly. And really it's left to me to thank David and Karen very much for your expertise, for your work, and for your insights today. It's been very interesting and always really interesting to delve a bit deeper into some of these issues that come up. So thank you very much, David. Thank you very much, Karen. And thank you very much to everyone who attended today's webinar. And we do hope that you will join us again for the third in this series on the 14th of September. Thank you very much.